Liz unexpectedly left Tucker's side and moved closer to the pit of hot rocks, eventually coming to rest on Tucker's legs. When Miss Tucker tried to get Liz to come back, Liz brushed her hand away, and Tucker, so concerned about Liz's condition, called out to defendant and called him by name. "James, it's Laura. I'm concerned about Liz." Ms. Tucker testified that the defendant did not investigate the situation, did not come check up on Liz, did not ask any other staff members to check up on Liz, but instead proclaimed from his spot by the door that Liz has done this before and she knows what she's doing. Liz, having heard Mr. Ray himself just tell her that she was fine, Liz says no, not moving except to turn her head. Ms. Tucker testified because she heard the defendant say Liz knew what she was doing, and because Liz had responded promptly that she let things be. Or Lori Gennari describes Liz Newman as a person who is obviously collapsing. Ms. Gennari testified that she had suspended her normal common sense in order to have the experience as instructed and promised by the defendant, and that she had been instructed many times by the defendant to let them have their own experience. Yet another witness who sets aside their own instinct to take care of people because the defendant has told them to let people have their own experience, and because the defendant has told them that this is normal and they don't know what to expect. Melissa Phillips testified that she herself saw Kirby Brown, noted the distress of Kirby, and called out 5 to 6 times that there was something wrong with Kirby and that she needed to be taken out. The defendant had said, "We'll check up with her after the end of the round," and he did not. The 6th round came to an end, and instead of at that point, as he had promised, checking up on Kirby, the defendant then started the 7th round. James Shore dragged out Sydney Spencer, came back. The first time she was interviewed by the detective, what she told the detective was that James Shore came back, yelled out that Kirby Brown needed help. On the stand, she testified that he came back and he put it out there that Kirby Brown needed help. That was between the 6th and the 7th. The defendant, according to many witnesses, responded, "The door is closing. We'll deal with it, or we'll deal with it at the end of the next round." The defendant then goes through the entire 7th round, Your Honor, knowing now that Kirby Brown is in trouble. The 7th round comes to an end, and according to Don Gordon, James Shore again calls out for help, calls out that he needs help with Kirby. And again, the defendant responds, "The door is closing. It's too late." And what Don Gordon's testimony is, at that point, James Shore then tries to get some air from the edge by lifting the edge of the tent, creating light. And now we're into the last round. He lifts up the edge of the tent, creates light. Having failed to get the defendant to get Kirby out, he's now trying to get air for Kirby and for himself. Creates light. And the defendant yells out, "Turn off the light." At that point, he puts down the edge of the flap. Don Gordon testified she continued to hear the labored breathing of Kirby up toward the end of round 8, but by the end of round 8, all is quiet. Debbie Mercer testifies about the 6th or the 7th round, how she sees James Shore bring out Sydney Spencer, knock his head on a post, and the autopsy does show an abrasion on his upper forehead. How he turns around and goes back in, and then she hears someone say, "So-and-so's unconscious, I can't get them to respond." And from her position right next to the defendant, she testifies she hears the defendant reply, "Really? They're not breathing?" And someone answers no, and the defendant says they'll be fine. That's where they need to be. Sarah Mercer testified that she heard someone say there were a few people unconscious and that the defendant said it was a good day to die. That someone asked the defendant if they should take them out, and Mr. Ray replied they had just one round to leave them there, they would be okay. And then Fawn Foster testified that she heard that there were 3 people down and heard the defendant ask whether they were breathing. She did not hear the reply, but she did hear the defendant say, "Leave them until the end of the next round." That Mr. Ray himself knows his sweat lodge events, his heat events are hotter, and intends for them to be hotter than any other person's sweat lodge ceremonies. That he intentionally calls for more rocks and water than other facilitators do. We know from the testimony that he doesn't check up on anybody during the ceremony or between rounds. And we know, of course, that he continued the event in spite of the obvious distress of many participants, including the victims.
The defendant didn't raise an issue with the indictment, and because the defendant had full disclosure about the state's case, the police reports and that sort of thing, which has also occurred here, that there was no actionable violation of due process. I mean, a simple civil negligence, the state has provided substantial evidence that Mr. Ray's conduct rose to reckless conduct and certainly to negligent conduct. Mr. Lee argued that we have to prove that the defendant knew the victim was helpless. That's not the case. Restatement section 322 says if the actor knows or has reason to know. In this case, the jury's been provided with ample evidence that Mr. Ray knew and had reason to know that people were helpless, the victims were helpless. Not only did Mr. Ray tell the participants you can become unconscious and pass out, which shows he recognized that that was a possibility, there's been the testimony of witnesses about the statements that were made to Mr. Ray and about his responses, "Leave them be, the door is closing." That's evidence that shows that Mr. Ray knew and had reason to know that the victims were helpless in this particular case. And in particular, that duty arose not only at the time that the sweat lodge ceremony ended, but it arose when he first became aware that there was a problem, and that was when the participants, at the very latest, when the participants were starting to pipe up and say things like, "She's passed out" or "She's not breathing."
Thank you, Mr. Hughes. Mr. Lee, 12 minutes.
Yes, Billy, there's literally no testimony related.
Critical, Your Honor. It is obvious. I have a 7-year-old. I'm not going to leave my 7-year-old in the car with the windows rolled up because she is not somebody who's legally capable, not just because, she's just not, everybody knows you can't leave your child in the car, okay?
There's just literally no testimony.
Just a barrage, a fire hose. It's amazing that this, that's sophistry. The fact that folks were dying. Mr. Shore, starting with, there is literally no evidence that anybody knew he was dying. Nobody knew. There's literally no evidence at all. They are literally arguing.
And I conclude that the defendant, Mr. Ray, owed a legal duty to the decedents. The state has presented substantial evidence as to voluntary acts as well as omissions. With regard to mens rea, I conclude there is substantial evidence of the mental state of recklessness. With regard to causation, I conclude there is substantial evidence going to both cause and fact or but-for causation as well as proximate cause, and I conclude that there has not been a violation of First Amendment principles in the presentation of evidence. And I also conclude in this Rule 20 context that there has not been a due process violation. In summary, it's order denying the motion pursuant to Rule 20.